Good afternoon, Judge.
Good afternoon. Can you hear me?
Yes. We wanted to do a test before we join everyone else so that we see if the panelists and the moderators can be heard. But yes.
Okay. Have you managed to get
Judge?
Hi, hello. How are you?
I'm good. Karibu sana.
Asante. The head of the family division, is he here? That's what I wanted to inquire.
We're waiting for him to join in. Let me just inquire with Chair and get back in a minute.
He's the primary person, so he needs to be in. Thanks.
Yes.
Judge, maybe as we wait for the confirmation, you had I would be moderating the plenary session. Is there, and I think you received the questions that we shared.
Yes, I did. Thank you. I did.
Okay. Yes. Is there, and I wanted us maybe just before we start off, we could do a bit of reflection in terms of the, how do I say it, the backdrop of the Marriage Act, just a short snippet, and then we get into the questions. Is that okay?
You'd be welcome.
All right. Okay. Thank you.
I'm hoping that this is also more of a conversation around the issue than, do you have answers, strict answers for us? I think it's a big problem. I'm hoping we're really going to have an engaging conversation on it.
Yes. That's a hope that we can have a more of a discussion in terms of from where you're seated as sitting at the apex court, and then having the decisions that we had shared, and also then having Honorable Riechi with us, giving us his perspective, and between that, so that we can just have the discussion around that, and then we'll have more of asking questions, dealing with a Q&A towards the very end, and then you would then give us your reflections on the discussion. So it's really more of a relaxed conversation. Good afternoon, Judge Riechi.
Good afternoon.
Yes. Good afternoon, Judge.
Sorry, I'm late.
Yes, so I think now we'll have Wendy join us, and just before that, my name is Modoni Gashara. I'm council member Nairobi branch. I'm very glad to have you here, and we'll be co-moderating with my senior, Miss Wanjiro Kiniti. Now we are very glad to have you. So we'll now have the others join us so that we can begin the session. Wendy?
Just one.
Yes.
Just one issue, and that's why I was saying I'm hoping it's going to be an engaging conversation. Judge and I, we have some constraints. There are certain things we will not be able to say or not say outside of the decisions that have been made by courts. Of course, we can give our personal views, but I just wanted, perhaps you can let those who are asking us questions know that there are limits to what we can actually say as judges.
Yes. Very well. With us is Wendy. She's a program officer at the branch, and she'll also be helping us to coordinate. She's an advocate as well.
So should I let the other members join?
Yes. And when Chair joins, please also let me know, because
Okay. Good afternoon, everyone. Thank you for joining us for this webinar. Muthoni, are you there with us? I would like to confirm that the chair has joined, so you can proceed. Thank you.
Very well. Thank you, Wendy. Good afternoon, members. My name is Muthoni Gashara, council member in the branch. We are glad to have you. We are also honored this afternoon to have Lady Justice Njoki, the judge of the Supreme Court, with us today, and Justice Riechi, Judge Milimani High Court, Family Division. We are honored to have you in our presence. We are also honored to have our chair in our presence, and at this juncture, I will invite our chair to give the opening remark.
Very well. Thank you, Madam Organizing Secretary Muthoni. I'd like really to take this opportunity to thank your leadership and my Lord, Justice Riechi, for finding time to come and just discuss with us this very timely and consequential topic. We don't take it for granted, and we are truly grateful. I will not take much time because I am seeing we have more than 140 members tuned in just to participate in this. I'm looking forward to a riveting discussion. I know that even among my members, we have people in arrangements that are not registered and known to law. So maybe from the bench, we will get the perspective on whether the Marriage Act is ahead of our time. Do we need to review the laws and contextualize our current circumstances? Or is it for us to up our game and register our different arrangements? I am looking forward to a very engaging session. Thank you very much. And I am truly honored by the number of members who have joined us this afternoon. Karibuni sana, and please feel free to engage. Thank you so much. Asante sana.
Thank you very much, Chair. We will be moderating with my senior, Ms. Wanjiru Kiniti. So I will proceed. Honorable Lady Justice Njoki is a judge of the Supreme Court. She's an advocate of the High Court of Kenya and holds a master's in law, degree in human rights and civil liberties, and a diploma in human rights. She has previously worked as a state counsel in the Office of the Attorney General. She has also worked as a program officer at the Institute of Education in Democracy, and also as a national protection officer at the United Nations High Commissioner for Refugees, and also as a political analyst in the conflict management at the African Union. Lady Justice Njoki Ndung'u is a former member of the Pan-African Parliament and also a member of the 9th Parliament of the Republic of Kenya, where she sat in the standing committees on defense and foreign affairs, administration of justice and legal affairs, and the Parliamentary Select Committee on the Constitution. She is the architect of the Sexual Offences Act 2006 and of the amendments to the Employment Act 2007, providing for paid maternity and paternity leave, as well as the Political Parties Act 2007 on the affirmative action measures for women in political participation. Lady Justice Njoki sat as a member of the committee of experts that drafted the Kenyan Constitution and has received international and national recognition for her work. She was awarded the UN Person of the Year in the year 2006 and the International Commission of Jurists Jurist of the Year Award in the year 2006. Further, she has received presidential commendation of the rank of the Elder of the Burning Spear EBS in the year 2006 and later awarded the rank of Chief of Burning Spears CBS. Lady Justice Njoki heads the Supreme Court Governance and Regulatory Affairs portfolio. This portfolio focuses on the effective governance of the Supreme Court to ensure consistency and predictability in the management of the courts, and also to achieve a well-developed and effective governance structure. There is need to include a set of rules and responsibilities for individuals, as well as direction and strategies for the management of the courts. We also have Honorable Justice Drechi. Honorable Justice Drechi is a judge of the High Court of Kenya. Justice Drechi holds a Master's of Business Administration MBA, Strategic Management from the University of Nairobi, Bachelor's of Law from the University of Nairobi, and a postgraduate diploma in law from the Kenya School of Law. He joined the judicial service as a magistrate in the year 1986 and rose through the ranks to becoming a chief magistrate, having served at various stations, including Lodwar, Bungoma, and now at the Milimani High Court. In 2015, he was appointed as a judge of the High Court of Kenya and is currently serving at the Milimani High Court Family Division. We are so honored to have you. I will proceed to allow my co-moderator to proceed. Karibu Wanjiru.
Thank you very much, Muthoni. Honorable judges and our chair Nairobi branch and members, good afternoon. Karibuni sana to our discussion this afternoon. We are going to have a conversation, and I think that helps us to be able to set the tone and understand what lays before us. We want to be very fast. We're very grateful, Honorable Lady Justice Njoki, Honorable Riechi, for taking your time to have this conversation, which our chair says is so much in time. And it's one of the things that we have been having conversations on. Members of the public have drawn such an interest in it. And so the title of the webinar, for me, drew an interest because it helps us to try and navigate through the question of two questions. The first question would be, what is the place of the unregistered marriages, customary marriages? And then the question of division of matrimonial property. And I think judges would agree that we would have to first determine whether there was a marriage for us to be able to get into the question of division of property. When I was reflecting on today's topic and thinking about how do we navigate the conversation, I thought of this African saying that speaks to the concept of marriage. And it basically helps us understand that from the African lenses, marriage is not really about what we put down on pen and paper. So the registration process doesn't really happen in the way we envision it in statute. But marriage is how you live out your life. And so from the legal perspective, then we have now the dynamic of the provision of the Marriage Act and what our customs provide. So in terms of just setting the legal framework for the discussion today, we will be examining or looking at the Marriage Act of 2014, and we will also touch a little bit on the Matrimonial Property Act of 2013. So to set us off, I would invite the honorable judges just to give us their view, because there's a history behind the Marriage Act. We are coming from a place where we had different pieces of legislation dealing with different types of marriages, and we had scattered legislation. And I remember one of the key things that the Marriage Act of 2014 sought to deal with was uniformity in terms of application of the law. So as a way of just helping us understand and appreciate where we are, I would want to invite Lady Justice Njoki to just help us understand the background against the Marriage Act. Maybe of the 142 members we have, we might have some who are not aware that we had 7 different, I think there are 7 different pieces of legislation that dealt with different types of marriages. And so just drawing us from that background to where we are. Karibu sana, Judge.
Thank you very much, Council. I wasn't expecting that question actually, but that's fine. It's something that I have an interest in, and so I'll be able to speak a little bit to that. I just wanted to say, and allow me to do this, to make a disclaimer that my views on these issues are largely personal, except where decisions of courts have been made and decisions of the Supreme Court. Council, you don't come before the Supreme Court and say, but you in the webinar you did this. So just to be clear, this is part of a conversation, and a lot of what I will say is what I think personally. The history of the Marriage Act is one that has taken over 30 years before its enactment in 2014. A group of civil society organizations after Beijing in 1995 with regard to marriage, divorce, resulted in the appointment of a task force by President Daniel Arap Moi, a task force that was headed by Justice Effie Owo, in which the task force looked at all the issues around family law and made recommendations as to what laws needed to be changed. As it was, under the system of marriages, we had 5 ways in which Kenyans could contract a lawful marriage. 1, they could contract a civil marriage by going to the Attorney General's chambers, and a registrar and the Attorney General's chambers would register that marriage. It is still being done. It's called a civil marriage. Secondly, there were the marriages under the African Christian and Divorce, the African Christian Marriage and Divorce Act. They would go to a church, and in these marriages, polygamy was discouraged, and therefore this form of African Christian marriage was a monogamous marriage, as is the civil marriages which were registered by the Attorney General. They were then the Hindu marriages, which were originally polygamous, but now as it stands, they are monogamous marriages. There was then the Mohammedan Marriage Act, which the Muslims would get married under. It's potentially polygamous, and the disputes in that under that act were managed through the Qadi's court. And finally, there was the African customary marriage. No statute covered these marriages. Most of us go to a textbook. I'm trying to remember the name of that textbook. I'm sure all of you remember it. It was a textbook, I think by Jackson, Tudor Jackson, if I'm not wrong. And he had simply given a summary of the traditions of different African customary marriages in Kenya and what those marriages, the ceremonies that constitute those marriages. But there was never any statute. And those were not registered per se, as we know, we understand registration under the laws of Kenya. So the 2014 Act was to put all these different marriages to a lifestyle, and a contract which under statute could be registered, a contract under which the parties could claim rights and parties could have obligations, and the courts could then manage any disputes that would emerge from those. A primary point or succession would be relative to marriage ceremonies. But this was difficult because once, for example, a husband is dead, sometimes the widow will be thrown with the person is married. Where for which registration was being sought. There was a reason, and I'm glad we
Judge, I think there's a connection challenge. You must be experiencing some challenges with the connection.
Yes, I am. If you allow me, I am going to switch devices. Yes, please allow me kindly.
Okay, that's okay. Yes, that's okay. As we have the judge trying to get herself situated with the connectivity issue, Honorable Justice Riechi, an important question or distinction has been raised before we got ourselves to the 2014 Act, the different types or the multiplicity in terms of legislation. Maybe you could share with us your thoughts with regards to the history, your perspective or perception of the history to where we are today, and maybe touch a little bit on the gains that we can see from that history. Karibu, Judge.
Thank you very much for inviting us. Thank you, the LSK, for this webinar. As you rightly put it in the introduction, I work at the Milimani Law Courts Family Division. In the Family Division, we are 6 judges. We are very grateful to the Chief Justice that he gave us 2 more judges. And basically, we handle all matters family. Succession, we do matrimonial, we handle mental health, we handle adoption, and we also handle appeals from the Children's Court and from the lower courts. These are challenging, it's a very challenging division because it normally deals with the issues which are on the ground. They are not abstract, they are the day-to-day issues which we deal with. Coming to the issue of the Marriage Act. So when you were introducing me, and I think this one I will pull it down from the website. I joined the judiciary in 1986. Whenever you mention that, it looks like I'm about 40 years old in the judiciary, and that makes me feel very old. But thank you for that. For the judge has mentioned the regimes, marriage regimes, which he has stated, and the most problematic one has always been the customary one for judicial officers. If you are in Homa Bay, for instance, you ought to know the marriage processes of the Luo community. If you are transferred to Eldoret, you need to know the Kalenjin words. So sometimes we had to deal with, we ask any parties to call as a witness a person who is versed with the customary law of that community, for you to understand if you are handling a matter, a divorce or any matter relating to property. What this Marriage Act has done is to standardize what is it that we want, what is it that is to be proved. Attempts had been made to solve that problem with the publication by Judge Cotran, Casebook on Kenya Customary Law. It was a very useful tool for all of us because it tried to document what each community, what constituted a marriage. So for me, the Marriage Act now as it is saves us the issue of determining whether there was a customary marriage. By registration alone, you don't need to go back to what all the formalities were complied with. All you need to say is, well, I'm married now under Kamba customary law, and then I have a certificate, and that's all. For the judge, that will be all. It saves both time and the expense on the parties. Yes, the enactment of the act has brought its own issues, and I think it's not something we cannot anticipate, but it saves us from the judiciary point of view. It saves us the burden of doing some of the things which we used to do previously. I think now a judge could have changed devices and it will be allowed to go on.
I am hopeful that she has managed to transition to the other. Well, then, are you able to confirm if the judge is with us?
Not yet.
Okay.
We're waiting for her.
Okay, all right.
We're waiting for her.
Yes.
For me, that is the greatest achievement in this Marriage Act.
Thank you, Judge. And what comes out from your history and appreciation, or there we have
Judge, yes.
Judge, yes. Yes, maybe Judge, you can just finish your thought on the history, and then we can pick it up from there.
Sorry, let me apologize very much for, I'm working out of the office, although to tell you the truth, the network at the office is not, it's equally terrible. So I've just, I've changed my gadgets. I hope it will be better now. I was just talking about the history and saying that one of the things that was very problematic was when people would come to court and they were unable to prove that they were married under customary law. Unlike those who were coming under the other marriage regimes where there was certification and registration. And that is what informed the registration of customary marriages. I think in this conversation, apart from looking at the law itself and at the decisions of the court, I think we must explore what is it? Why is it that those who get married under customary law, what is it that is preventing them from registering marriages? Of course, there are those who have been married before the act, but those who are married now, because I was exploring how you get married, how you register a marriage, and it's a simple process to go onto eCitizen and to register that marriage. The same thing that we do when you want a driving license, you go onto the NTSA website. When you want to register a birth or death, you go onto online and register. My question was, or my thinking was, perhaps there is no incentive at the time you're getting married. As counsel, you said, marriage is something that we do, it's a lifestyle. So once you are living with somebody, you're already living with them. What is the incentive to go and register? Of course, until you run into problems. And perhaps at the time of getting married, those problems you are not able to see down the line that you may have problems of proving that you are married. And so therefore, we need to ask ourselves that question. Why are people registering? Is this the responsibility of the Attorney General, under whom the registry of marriage, that docket belongs? Is this the responsibility of the office of the president, because chiefs are involved in terms of registering these marriages? Who is responsible for the non-registration? What is really the cause? Because the judiciary and the judges cannot resolve some of these challenges that exist. I will leave my thoughts there for the time being and hand it back to you, Counsel. Thank you for now.
Thank you, Judge. Thank you, Judge, for that brief background and helping us just understand where we are coming from and where we are, and Honorable Riechi's contribution towards the appreciation of the Act. He had told us it makes now the court process much easier. And I like that you posed the question to us in terms of where is the difficulty. And when I thought about that in terms of incentive, it's true. I think the marriage becomes very incentive as of that point. But until you get into a legal problem, then registration is key. So we now have the Act in place. And one of the key requirements is that we need to have these marriages registered. Now, the Act comes into place in 2014. So we have many, many marriages that are conducted prior to the Act, and like you have rightfully indicated to us, that did not require registration. There is a timeline to have those marriages registered. Now we find ourselves, and this is where we appreciate the wisdom of the judges, being faced with a question of how do we deal effectively with a marriage that is not registered? And maybe Honorable Riechi would give us, because you are in the family court division, you are dealing with a lot of these cases. How does the court then deal with a marriage that was conducted, for example, in 1980, under the law customary provisions, but has not been registered? Do we then say that for lack of registration, then you do not have a marriage, and sweep all those many years under the bridge? Or how do we help parties reconcile the non-registration of customary marriage and legal problems that they would be facing in court?
Thank you very much, Judge, for that instruction. But the question which you ask, and I think we ask ourselves, among all the 140 you said, if you ask them, are you married? They'll all tell you, yes, I'm married. Why? How? Because I have a wife and I have children. If you ask them, have they registered the marriage? 90% will say they have not registered. Then the next question is, why have you not registered? Are you aware? Even the ones who are aware, like all of us in the 140, we have not registered our marriages. So we need to find out, as Judge said, what is it that is preventing us from registering the marriage? Let's start from the lady, the wife. Why have you not asked that since we are married, why have we not registered that marriage? Why have you not asked that important question? For the man, why have you know it, but why have you not gone to register it? So we must, as we are discussing this, there must be something which discourages us from going for registration, which we need to find out, not in this forum, but perhaps if everybody has his own reasons. But granted that with the coming up of the Act It's now 11 years old. We have had disputes coming to us under the Act. And the good thing is the Act made specific provisions on registration. There was a timeline for registration, and the consequences of registration are also there. It said, it has provided for that where marriage has not been registered, it's voidable. It has gone ahead and said what is voidable, avoidable marriage. Section 12. It has stated all the what will constitute avoidable marriage. So one of them, and the last one, is that there was failure to register the marriage. That is the last one. There are many, but the last one is the marriage is voidable on the ground that there was failure to register a marriage. My understanding is that a void marriage is one which does not exist because it was conducted by underage. They have given all what will constitute a void marriage. Avoidable to me is that it exists legally until it's annulled by one party, an application by one party or both parties. So my understanding will be that if there is a marriage, you are married, all the customary processes have been complied with, your dowry has been paid, you have stayed together, you're married, you have indicated everywhere that you are married, and nobody has gone to register it. The greatest threat is that somebody will come and say you are not married, it's to void the marriage. That is the greatest threat to you. But so long as nobody comes to say this marriage is void because of failure, voidable, there is no application, then it still remains a marriage. The only problem is this: if you coming to us and telling us that yes, I'm married under low customary law, then we'll ask you for the certificate. You say I don't have. Then you tell us how you are married under customary law. For me, it will mean that now you have to prove the marriage. That I was 18, dowry was paid, so ceremonies were done, and then we're staying together. Then you have to prove that. So, certificate avoids saves you from adducing this kind of evidence. I guess it's just like a mechanic. If a mechanic, somebody comes and says, "Oh, I'm a mechanic. What is it that, madam, you have? This engine of mine is not working," and so on and so forth. So I'm a mechanic, and you tell him, "Okay, where do you have a certificate?" "Yes, I have a certificate from automotive engineering, the way they do it from Kenya Polytechnic." You'll allow him to look at your vehicle and do the repairs that you want. If he comes, he says, "Do you have a certificate?" "No, I don't have, but I know I'm a mechanic and I can do this." What will you do? You'll ask somebody to come and say, "Look, let me see how you open the engine first." It's showing you. You can see now, start from the way he's handling the spanner, and see this one has never gone to anything. So it's just that. So what to me is that the fact that you have not registered the marriage does not mean that it does not exist. It exists until it is annulled by the court on the application of one of the parties. Thank you.
Thank you very much, Judge. And the analogy of the mechanic and having to prove and demonstrate that indeed you are a mechanic. maybe picking up from that, we have had individuals and lawyers, colleagues who argue that Article 159 would be a saving grace to unregistered marriages in terms of they classify the registration process as undue technicality in terms of the registration. Others have argued that they find refuge in the saving grace, as it were, of Section 98. Lady Justice Njoki, I don't know what your thoughts would be if, and again, we appreciate we're having a conversation, sitting at the apex court and maybe not having dealt with this question. What would be your thoughts to a lawyer who argues that I find grace in Section 98, I find refuge in Article 159?
Well, let me just say this, and I'm glad you said this. Nothing like this has yet reached the Supreme Court, so we have not made a determination at all. I would just give my thoughts. And before I answer your question, I think we need to have a clear understanding. What is marriage? Is marriage a legal contract? If it's a legal contract like any other contract, by what means is it recognized? So we must answer that question. And then say, and maybe I'm speaking strictly, I'll come back to the practicality of it, is to say, can we then say that if I cannot prove a contract by registration, or can I lean on Article 151 and say this is a procedural technicality? As lawyers, what would you do if the law of contract became something which you could say, but you know, if there's no proof, it's a technicality. And then the courts would have to do the heavy lifting of seeing, did you meet? When did you agree? Are there witnesses? So I think we need to think through this. What is marriage? Is marriage a contract? Also, nowadays, there are those who cohabit with no intention of being married. So, how will we know who is cohabitating and they are married, and those who are cohabiting and they have no intention of being married? And for me, the difference between the two categories would be the registration of the marriage, that the parties have indicated that they wish to be married. And in the recent Supreme Court decision, when we spoke to presumption of marriage, and we talked about the union of persons who will cohabit without the intention of marriage, you know, we talked about that do people intend to be married or do they not? And I think that perhaps our courts need to look at that also, because the time will come when people come and tell us, I'm not married to so-and-so, and therefore this property is not matrimonial property, and the other person is insisting that they are. How would a court make that determination? There is a further complicated situation, which is just a Kenyan problem or a Kenyan challenge, because I call it, we do this all the time, and I'm sure out of the more than 100 people in this webinar, many of us have done it. We know what a monogamous marriage is. We know what a polygamous marriage is. But what do? We enter into a customary marriage because we always have a traditional wedding. And then we go and we contract a civil or a Christian marriage in a church by the Aegis Chambers, which is a monogamous marriage. Should that challenge come to the court, what would the court do? Do we take the first marriage, the first in line? Do we take the second marriage? So I think, I don't know if it's a question of civic education, but even lawyers themselves do it. Even judges are doing it. So the law on marriage, is this something that ought to be taught even in schools? Like civic education in schools, where people know almost everyone is going to contract a marriage. What is it? And how should it be conducted? So that sometimes people do bring their disputes and questions, as you have, to the judges to determine. But the judges also have jurisdictional limits. They can't change the law. They can't undo the law. They can only apply and interpret the law. And certainly, a law, like one of technical procedure, which is only supposed to be used in exceptions, can now not become the law that's used for over, did you say 1 million marriages? Then it is not, it's not an exception. It is the norm. Or do we want to go back to the marriage law and reflect upon it? But we need to know what is it, just going back to what I was talking about earlier. We register for a driving license. When you buy a car, you register your car. When you have a child, you register the birth. When your parent dies, you register the death. But there is something about registration of marriage which we are not able to do. And we need to, I'm sorry I keep on coming back to that. But in the end, all these things we are discussing today, finally, that is the question we need to answer. So I'm not sure if I answered your question at all. As you can see, this is a topic that excites me quite a bit. But thank you.
Thank you, Judge. Yes, you did. And what I pick from the conversation that we are having, and maybe we could give the 142 of us on the call the responsibility to advocate, to teach, and to spread the gospel that there's need to register the marriages, because the law is very clear. Now, there's a concept or component that you've introduced with regard to property, because then at the point of getting into the marriage, I might not really be concerned on its registration. I might be enjoying, this new union that we are forming with my husband. And 10 years down the line, we encounter a challenge. Now, we have come before the court. We have proved that we were married, whether we had the certificate or not. Maybe we have understood the importance. We cannot, underscore that more in terms of registration. So then how does the court look at the division of matrimonial property from a customary marriage perspective, appreciating the nuances of Section 7? And I find it like a unique provision when you read Section 8.1 of the Marriage Act, because as we know, customary marriages, the Marriage Act speaks to their potential of expansion. There's a potency for it to expand. So we have one where it has expanded, and maybe the spouses are more than one. And in Section 7, the Act of the Matrimonial Property Act speaks towards contribution. You will get what you put in. But in Section 8.1, we have now another introduction of how we are dividing this matrimonial property between a polygamous institution. Maybe Honorable Justice Rich, what are your thoughts when it comes to, or challenges maybe in terms of appreciating the provisions of Section 7 in terms of customary law marriages and the question of contribution?
Thank you very much. I think registration of marriages can save us a lot in terms of evidence. You wonder sometimes, particularly, it will be very helpful for the second family, particularly when the husband has died and the second family is not recognized by the first family as being a wife. 70% of the succession matters which we deal with, and the issues are basically that whether so-and-so, to determine whether so-and-so was a wife of the deceased. They normally do not have a problem with the first wife. Even the second wife will say, look, I know that one was there. But the only explanation they'll give is, he told me I'm Pendi. amemwacha, something like that, which all men do. I don't know whether all, but that is the reason now they come in. They agree on the first one, but the second one, the first one will say that she was a wife, and 90% of the matters we deal with in those cases to determine whether so and so who is the second wife was a wife. The husband is not there to tell us. Now you need to call other people to say how they were married. It's very tricky, and it's in the interest of the second family to have that marriage registered. Otherwise, it will be problematic for them. Coming to marriage, particularly customary marriage, some things amuse me. Are you married? Are you the applicant? Yes. Do you know the respondent? Yes, I do. Who is he? My ex-husband. When did you marry? And that's where problems start. They don't know when they were married. The date of the marriage is always very difficult for people. I have never known why. Sometimes we try to devise ways of finding out the date. If they are all very old, then you ask them who was the president then. And they tell you it's Kenyatta. Now, Kenyatta, you can know that he must have been before 1978. That is okay. But what to you if they tell you it was Moi? Moi was there for 24 years. So when do you find the date? That's one of the things I don't understand. But in terms of tactics, we have now said, okay, fine. When was your firstborn child born? The moment that one they remember, all mothers remember the firstborn, the date of the father. They may not remember the actual date, but the month and the year. And then you start facing your date of marriage beyond. I guess it's because they sometimes know where there is no ceremony, there is no clear distinction between courtship and marriage. They really don't know when it transited from courtship to marriage. It's important that that one is known. In terms of matrimonial property, to me, the act is clear what constitutes matrimonial property. It's easier for us, and that's why we ask the first question: when were you married? And that will bring us to the question which Judge asked. There was a traditional one and a registration. Which one will we take? It hasn't come to us, but it will come. So once we have determined the date of marriage, the property which was acquired, and then it's easier now for us to determine whether that was matrimonial property. It's never difficult. In respect to polygamous marriages, and I think the case is the act is very clear. It's now, if there was property before the second wife came in, it will be between the first wife and the husband. And if there was anything after that, it is really stated very, very clearly. It's never a problem for us. So whenever it comes to customary marriages, in respect to that.
Judge, at the risk of putting you in or putting you in a corner, and allow me to ask this question with regard to 8.1. It is something that has troubled my mind when I look at it and I reflect on section 7. And then I appreciate that this might not have, is something maybe that has not been litigated on, but I find, and I don't know whether I would be right in saying this, I find the use of the word equal a bit troubling in terms of interpretation. Mm-hmm. So that then in terms of reflecting for me, I wonder, is that intentional for it being there? And how then do I appreciate that against the backdrop of section 7?
Mm-hmm. it hasn't come before me, so I haven't
Yes.
dealt with it. Probably haven't interacted with it, that issue. But I think for me, a plain reading of the three sections provides a good roadmap for a judicial officer in the terms of distribution.
Okay. Thank you, Judge. Thank you very much, Judge. So we have then, in terms of distributing, I have seen other jurisdictions where we are able to have a standardized, for lack of a better word, a uniformity in terms of dividing matrimonial property. Lady Justice Njoki, I do not know of such a position within our jurisdiction. And could we say that we are in a space where we need to be thinking about this and come up with a mechanism that guides the judges? Or do we continue with what is in place for us, where we allow the judges to exercise their discretion?
I must say, that's an interesting question, and it's one that I have participated in debate of. But I think in the end, it has to be within the law. Once again, let me say, there's only so much judges can do. If it's not specifically in the law, it's very difficult to deal with. The jurisdictions we're talking about, for example, in the US, in California, where the matrimonial property is called community property. Upon divorce, it's 50-50. But there is a clear written law that states that in our Kenyan legal system, we do not have a law that specifically states that. And therefore, a judge has to look at the evidence that is brought before him or her on the issue of contribution. Now, you know, contribution can be done in many ways. There is monetary contribution to property. There is non-monetary contribution. And even where it's monetary, it can be direct, like one person applying for the mortgage for the matrimonial home, but it can also be indirect. So as one person is paying for the matrimonial home through deductions through their salary, the other person is paying for the other expenses in the home in order for this other person to afford to pay for the matrimonial home. Those are financial contributions, but they're different contributions. Then there is, of course, non-financial. And the courts have said previously, even the act of childbirth itself would be considered a contribution. Child's care would be considered contribution. But I think it's incumbent upon the parties and the lawyers who come to argue for them to plead and to prove. So sometimes maybe you go into detail, you say, you know, we both work, but when I go home, he goes to network with the boys and I am at home every day and this is what I'm doing. But you have to say, the judge cannot guess that because you are a mother, these are the things that you did. The judge cannot guess. There has to be, you know, it has to be pleaded and where possible proven. Of course, now we are moving into the modern age. I can see more and more lawyers encouraging prenups. I think that's also something that needs to be looked at now, where people are now entering into marriages when they're already propertied, as opposed to a long time ago when the acquisition of property happened after marriage. And it's important, I think, to be able to register the marriage, the property that you have before you get married. I think, again, although we do not have a law covering prenuptials in detail, I think that that's a good practice that should be encouraged. It will also help the judges when these matters come to court. It makes it easier to separate the property that was acquired before marriage and that which was acquired during marriage. I was curious at what my fellow judge said. He said something about which all men do. I didn't quite catch. What is it that all men do? Is it something that women can do too? I'm saying that tongue in cheek though. So I hope I've responded to your question. Thank you.
Yes. Thank you, Judge, for your response, and in terms of helping us appreciate that the court can only do so much, and the responsibility really lies with the advocates and how they package and they present their cases before you. Maybe it is time, in terms of reflecting from where I sit and how I have seen the dynamics of family law grow throughout the system, maybe it is time that we rethought the structure in terms of having parties seriously look at the provisions of the prenuptial agreement, because like you say, it would help us be able to navigate the question of division of matrimonial property easier. Honorable Judge Riechi,
Yes.
did you wanted to contribute something? Or-
Yes.
Yes.
Just to say something about what all men do. You will reflect when you go home and see what he told you to be the truth when we went on the road, when he wanted you to go to his home. But half of it was not true. You knew him as a poor person in the village, but he'll always talk of a very big uncle in Nairobi to convince you that there is future in him if you married him. Coming up to the issue of distribution of property, I think the Act has given a good guide. It has stated what direct financial contribution is. It has stated what that we also have to consider non-monetary contributions, and has given us a schedule of what really will constitute that. Domestic work and management of the home. And I think I agree with the judge that sometimes parties come to court and assume that we know. I mean, how can you not know that I'm the one who cooks? I mean, I'm the one who takes care of the children. I'm the one who is doing this. No. What you tell us. You should tell us. I shouldn't work from the premise of what I know from other sources other than what you tell us. For instance, if you are coming saying I am not working and I am the one in charge of the domestic work and the management of the home, you tell us what is it that you are managing. Tell us, what do you do? Is it household work? Yes. Cleaning houses? Yes, you do. Are you washing dishes? Yes. Cooking? Yes. General care, home care? Yes. Tell us, itemize them so that we can appreciate what your role is. If you are working, for instance, both of you are working, the man is working, the lady is working, you leave the house at 8 and come back at 5. Now, who is doing this? You can't say you are doing it and at the same time say you are working from 8 to 5. You must say this one is being done by the nanny, but I'm the one who pays the nanny. That makes some sense to us if they hired staff. What about the management of the matrimonial home? That is something which we need to take into account. What is it that you do in terms of management? Are you the one paying rent? No. Are you the one paying security for the house? No. Are you the one paying service charge? No. Are you the one doing resident associations activities? No. Now, how do you want us to tell you, to say that you are now in managing of the home? That becomes really difficult for us, even when we are assessing. Childcare. The Act does not talk about childbearing. It talks about what? Childcare. So I guess there must be a distinction. There must be a distinction between childbearing and childcare. So tell us, what is it that you do? The age of the children, who takes care of them for the time when they are awake in almost 12 hours? Is it you or is it a nanny? Or did you only deal with a child for the maternity period of 6 months and then you went to your workplace? If you did that, that obviously is a factor we take into account in assessing your input in it. If it's companionship, it is there. Companionship, shared experiences. Do you have shared experiences? Do you have have you been giving emotional support? A genuine connection? Have you been enjoying each other's company? Are you doing things together? Are you been a shoulder to lean on? That's something we need to take into account. But you tell us I offered companionship, and in the divorce matter, what was the ground for divorce? Cruelty, desertion, adultery with known and unknown men or women. Tell me where the companionship is here now. And that we should give you 50% of that, because those are things which we take. Was there companionship in this? Were you a good companion to the other? Management of the business of the property of the family property. In most cases, most of them come to, for when it comes to this, it's rental income. And what do they say? Yes, I was involved in the management of family property. How? It's my father who identified the plot for that it was for sale, so I went and informed him. And then I also participated in the construction. Where is the plot? Is in Kayole. Which part of Kayole? I don't know. So when you start asking, how did you participate as a supervisor? How did you participate in the construction? Those are things which we look at. Some come and say, okay, yeah, I participated in the property. How did you participate? When he was taking the loan from Stanjat, I went and signed where there is provision for spouse or consent. You too. Yeah, that's all I did. Yeah, that shows you were married. That's perfectly okay. But what was your involvement in this property? Were you a manager? What about the big family business? Were you a manager? Were you an employee? Were you a shareholder? What role did you play? Please bring this out to us. It will be able to assist us to ascertain what you really mean by direct financial contribution, which has been stated there.
Thank you very much, Judge. I must admit, I'll be the first one to admit that as you unpacked the non-monetary, as you walked us through that, I think as a practitioner, I have new appreciation for the roles that the judges would have in trying to interpret and then apply the discretion in terms of apportioning a certain percentage to non-monetary. I think in my practice, I have always thought it's almost so automatic, but now I think I have a new appreciation that when I package my petition before the court, when I'm bringing my summons before the court in terms of division of matrimonial property, I want to be able to represent my client to the best and explain that to the judge so that they can also appreciate the argument that is being presented by my client. I think I would, in terms of looking at the time, I would want to have us deal with questions that our members have been posting in the chat box. And maybe I would, as I ask my colleague Modoni to prepare for this session, I have seen a very interesting question from the chat conversation, and it refers to, by Moriah Kimani. They ask, in a dispute, can a party to a customary marriage refute their own marriage and have it voided because it was not registered, even though it met all the requirements of customary law? And it makes me reflect on what Honorable Justice Riech began by telling us when we were dealing with the question of registration, and that marriage, for all intents and purposes, in terms of when you look at the distinction between void and voidable, it would be, for all intents and purposes of the law, it would still be a valid marriage unless a party applies to avoid it. At this juncture, allow me, because I do not think I'd have another opportunity to do this, but allow me to say thank you very much to the honorable judges for taking your time, Honorable Lady Justice Njoki and Honorable Rieti for your time and just sharing with us. We were having a conversation and just helping us to appreciate the concept of registration. My take home from the discussion, and I think this cuts across for the 150 members present here, is that we cannot underscore the importance of registration. We really need to emphasize, sorry, that's what I meant to say, in terms of the registration process. It would solve a lot of problems that the court is really dealing with. And the need for registering customary marriages, helping people back at home. For example, I think one of the key things that has come out clearly when we talk about registration is that people are not aware or people don't understand, yet the process is very straightforward. So there is need for us to have these marriages registered so that we can make our work and your work easier for us. Thank you for taking time. Thank you for indulging me and having the conversation with me. I'll hand over the discussion to Muthoni so that you can deal with the questions that I see coming in through. Thank you, Muthoni.
Thank you very much, Wanjiru. Thank you very much, Lady Justice Njoki and Justice Rieti for the discussion so far. We'll open up the Q&A, and just before that, the questions that members had forwarded. And this question is how to dissolve an unregistered customary marriage. Does one have to file for divorce or annulment? And Lady Justice Njoki and Justice Rieti, we had shared this case for EMM versus PMK, which is very interesting as its approach is on the strict statutory compliance of the statutory compliance. So the Honorable Court directed that since there was no registration, the petitioner in that specific matter should have filed for an annulment as opposed to a divorce. So kindly give us your views on this question. So how to dissolve an unregistered customary marriage? Justice Rieti, kindly. Does one have to file for divorce or an annulment? What are your views?
I think the options, thank you very much for that question. For me, the options are, I think all of us who have interacted with divorce proceedings in the lower court, especially in customary marriage, all of us, whenever we want to go for divorce, we say we were married under this law, this customary law, and we want it to be dissolved. If you go that way, you need to prove that there was a marriage, and then if that evidence is there, or the other party has to admit that there was a marriage, and if that one is there, then the court can go ahead and dissolve the marriage on the grounds which are set out in the Act. The other option now, which is available to you, is to say we were married under law customary law, for instance, but we were not. It's not registered, so I wanted it to be declared void, and that is also another channel of approaching the court with the same results.
Thank you, Judge. We will deal with 4 questions, and then we allow the justices to respond. So we will have the first people who've raised their hands, the first 4 people, and we will definitely observe the gender rule. So the first hand that is up is from my end is Dorothy. Please proceed to ask your question.
Good afternoon. honorable judges and my colleagues. I want to take this opportunity to say that I'm really grateful for this conversation that we are having. Just before I ask my question, I have a follow-up question on what the honorable judge has answered, stating that if there is an unregistered marriage, you can file for annulment of the customary marriage. My question is, in such a case, can one still file for matrimonial property if the marriage is found to be invalid? Then secondly, on the issue of you have an unregistered marriage and you want out, but you did a customary marriage, you failed to register with your partner. Now you have contributed to this marriage whereby maybe you were involved in developing properties, buying properties as a couple. If the marriage is invalidated, am I still entitled for the matrimonial property? Thank you.
Maybe Judge Richie, you could maybe respond on that question.
When do you approach the court for matrimonial? Is when the marriage has been dissolved, isn't it?
Yes.
Thank you.
Most obliged.
Daniel, please ask your question.
Thank you very much, Honorable Justices, for the very good presentation. My question is largely on the issue of cohabitation, especially before 2014. So where there is no clear evidence of customary marriage, but there's strong evidence on cohabitation. And especially, okay, so within the 3 years grace period, if parties choose to go separate ways within the 3 years grace period, can cohabitation be a strong enough element to prove a validity of marriage?
We could also have Judge Richie also answer that question kindly.
That with it. Judge.
Judge Richie, I think the question was to you, but I could also say, I mean, the Supreme Court recently settled a matter in which we talked about the presumption of marriage. And this would apply to the situation you're talking about before the Act, as we were making a determination under the Married Women Property Act, but the Married Women Property Act did not apply in this particular case for the reasons the facts of the case were different. But we did say where you can claim presumption of marriage, you can, if you've had a number of issues. Let me just read them for you. So the requirements of presumption of marriage are as follows. Parties must have cohabited for a long duration. Parties must have the legal capacity to marry. Parties must have intended to marry. There must be mutual consent to the marriage. Parties must have held themselves out publicly to be married. The burden of proving the presumption lies on the party alleging it, and the evidence rebutting presumption has to be strong, distinct, satisfactory, and conclusive, and the standard of proof for presumption of marriage is on a balance of probabilities. So it is possible that you could come, although we say that this is the exception, that you could come and seek for a declaration of presumption of marriage. And on that basis, if a court presumes that you are married, you can then now seek for division of matrimonial property. But I want to agree with Justice Richie that there has to be a marriage in order for there to be a claim on matrimonial property. However, in the same case which I'm talking about, which was MNK versus POM, it is we delivered it in 2023. We did talk about where couples are not married, where there is cohabitation, where there are persons who are cohabiting, they are not married, no intentions of getting married, and they have acquired property. What ought to happen? And we said that it will be assumed there is a constructive trust, and the law that relates to constructive trust would then apply to that property. So I hope that has answered your question.
Thank you.
Great, thank you, Justice.
Thank you very much, Justice Njoki. There's a
Yes.
question that
Okay,
has been posed.
Just
Very
to
well.
add something about presumption of marriage.
Yes, Judge.
From where I sit, I sympathize with quite a number of litigants who come before us. Let's start with when somebody is filing for divorce in the lower court. Sometimes they are not sure whether they were married under customary law, or is it that they should be presumed to be married. So the starting point, and I think this is where the problem comes in, is somebody goes to the lower court, says I was married under customary law, full stop. And then you go proceed on that. When you find that there was no marriage, they say, but we have been staying together for so many years. How can you say that there was no marriage? So what they are alluding to is that the court should have presumed that there was what? There was a marriage, presumption of marriage. It's not for the judge to decide that. It's for you to say, well, I was married under customary law. If that is not what is there, have an alternative of a presumption. The court presume that there was a marriage. That will make our work much easier. Presumption of marriage, sometimes it becomes difficult for the courts. When the other party says, no, you should not presume a marriage. Why? The applicant in our NHIF forms, hizi tunajaza kwa form hapa. Unaandikwa marital status, unaandika single. Umetuma kwa NHIF ama she. KRA ikiuliza, are you married or marital status, naandika single. Iko kwa hiyo document zote. Kwa employer umeandika hapo kwa fomu ile ya kunini single. Then when you went to get a loan from Sheria Sacco, marital status, single. Now when you come to us and say, I want you to presume a marriage, presumption of marriage, that we are married, how do you reconcile this? Worse, it goes on when you started seeing that there was a problem in the family, and you went to the children's court or child support. You said an oath that you are not married, but you are a child. It becomes difficult for us. There's some measure of consistency which you should have as a person, so that it is easier for us to say, okay, you are staying for 18 years. That is really perfect, like a long time. Everybody knows you are a husband and wife, and you're behaving like that. But what about this small thing? What did you feel yourself as a person? That intention is reflected in the documents which you have filed. Thank you.
Thank you, Judge. There's a question that has been posed to Justice Njoki by my senior, Leah Kigwatha, and she's indicated that my question is for Lady Justice Njoki. Please say a bit more about the practice of converting a marriage from one type to another, which many Kenyans do when they do have a customary marriage, and then convert it thereafter to a civil or Christian marriage. What's the controversy around that when the Marriage Act allows for conversion under Section 8?
Okay. I think let me start by going back to one of the points I raised earlier, which is to say that I think that civic education needs to be done as a lifestyle subject in schools, so people understand what marriage is. So that what do we normally do? Many young Kenyans, or old Kenyans as it may be, we don't have a clear understanding of what constitutes a customary marriage. A customary marriage, for it to be a complete contract of marriage, must undertake all the ceremonies required under that particular custom. Once the ceremonies are complete, a customary marriage is now contracted and valid. Many of us undertake that customary marriage, we complete the ceremonies, but we think they are just ceremonies. We think that there is another ceremony that becomes a marriage. And that is a fallacy. Because, for example, in the Kikuyu customary law, once you have finished the Ngurario, after doing all the previous ceremonies that are required, the Ngurario is the final, that's the wedding, that is the marriage is finalized. After that, you are married. But I find people consider this to be a ceremony to bring families together. And then they go now to have what they call the marriage or the wedding in church. Yet those two marriages, the one in church and the one that is customary, are two different matrimonial regimes. One being monogamous, you cannot contract another marriage with another person, and one being for polygamous, potentially polygamous, where you can contract a marriage with another person. And that's the question. I don't think you can convert a potentially polygamous marriage into a monogamous one. The challenge has not yet come to the court. It'll be interesting to see how one can do that. Or vice versa. The law presumes that you will dissolve one marriage before entering another. That if you want to leave a polygamous marriage or potentially polygamous, you will dissolve it in order to enter monogamous. Or you will now leave your monogamous marriage in order to enter polygamous union. But that never happens. We just presume that the two can be done at the same time. I was very concerned about this, and I found, before I became a judge, I talked to a number of pastors. I went to churches and I said, before people get married in your church, do you talk to them about the law under which they're getting married? And one of them told me, no, it is the law of God. I said, no, the certificate that you issue comes from the government of Kenya. And it is a law of Kenya, not of God. You must be able to tell the people that you're marrying that although you have a Christian ceremony, the law under which they're getting married is this act, and these are the provisions in this act. These are the consequences of this act. Because it's not the church that marries you, but the law of Kenya provides for how you get married. So I find that this is something we don't understand. The pastors don't understand. And, you know, it's creating a lot of controversy. A lot of it has not reached the courts. In fact, it will be interesting because I also think a lot of judicial officers and judicial staff find themselves in the same situation. But it's something we need to reflect upon. Or is this something we need to accept that this is a uniquely Kenyan issue and therefore it should reflect in our laws and we can convert from one system to the other? But as it is right now, I don't think it is possible. And you know, we only see these problems when they eventually come to court, where people come and say, in fact, I'm not married to this one because she's still my wife. She cannot divorce me. She says I have another wife. But I'm allowed to because we had a customer a customary marriage. Well, whether as Kenyans we understand, as lawyers we are sharing, even as lawyers ourselves who enter marriages like this, whether we understand. So those are just my observations.
Thank you very much, Justice Njoki. We have more questions on the chat, and there is Bedan Mwangi is asking, how do you differentiate between polygamy and bigamy, especially in a customary marriage setup? Probably, Justice Njoki, you could give us your comment on it, as well as after that, Justice Jechi can also give us his comment on that question.
Bigamy can only be an offense within a marriage which is monogamous, or where somebody contracts several marriages after the first marriage is monogamous, and after that contracting other marriages. That could be bigamous. But where somebody is in a potentially polygamous marriage, to marry again cannot be bigamy.
Thank you very much, Judge. Judge Rechi, would you want to make any contributions on that question?
No, nothing much. Except the question which normally comes up is whether the person who was married under monogamous regime has capacity to marry these others. If he has no capacity, he has no capacity. Therefore, that marriage, that other marriage may be a bit tricky.
Thank you, Judge. There's a question from Moraya Kimani. He asks, in a dispute, can a party to a customary marriage refute their own marriage and have it voided because it was not registered, even though it met all the requirements of their customary law? Probably Judge Richie, you can give us your contributions on that question.
Sorry, I didn't get the question.
In a dispute,
Yes.
can a party to a customary marriage refute their own marriage and have it voided because it was not registered, even though it met all the requirements of the customary law?
I think the answer is in section 12. It's subject to the section 11. That's a marriage is voidable if the party they have indicated everything, and they have included in the last one that there was failure to register marriage.
Yeah.
So even if there was a customary marriage, every procedure was followed, dowry was paid, ratio was done, and but it was not registered. It's perfectly a marriage until it is voided by one party. So if it goes on that ground alone, I'm sure that will be a ground for annulling the marriage.
Yes, thank you, Judge. Daniel, is that a legendary hand or it's a current hand? Okay. Maybe before we wind up and see if we have any more questions, I would wish that Justice Njoki and Judge Rechi, you kindly give us your reflections on how how do we reconcile the provisions of Section 7 and Section 8(1) of the Matrimonial Property Act on property rights in polygamous marriages? We could start with the Judge JT.
I was just going to say,
Now-
I
now
thought
that
that
the
that was
Supreme Court-
an answered question. I thought that
Yeah,
was
it was
asked and
answered.
answered. Asked and answered.
Okay. Very well. Members, do we have anyone else with a question? I do not want to leave anyone out. We also have we had a very insightful comment from Ochil Dadri that as long as Kenya remains polyjural, this tension between respect for custom and compliance with statute will never end. I think that he says that he thinks that the insistence by courts on formal evidence of registration as the only proof of marriage creates interesting difficulties that contradict the aims of the Maputo Protocol. And he agrees with the courts that have resulted to presumption to respect the status of parties. Seeing that members are not raising any more hands or asking questions on the chat, then I would request that to sum up our topic today okay, there's a question that has come in. Let us respond to it. Kate says, as Lady Justice Njoki had pointed out, some cohabitants buy properties and division of such raises a dispute. What happens where the cohabitees registered the properties jointly? How do you handle the division of property? Lady Justice Njoki.
Yeah, that one is easy. That would give rise to a constructive trust, and the law is very clear on that. There would be no problem when you come to court and plead that. But now that I'm here, if you don't mind, I
Yes.
just wanted to respond. I'm sorry that Ochil has left the room. He normally engages us in very lively discussions. But I just want to emphasize that there's only so much the judges and the judiciary can do. And one of the things we cannot do is to flout the law. So if the law says that marriages have to be registered, even though we can be innovative when parties come before us, we cannot change that law. The only people who can change that law are the legislators. And perhaps the LSK needs to now start having an engagement with Parliament on this issue. But we find quite often, not just on family law issues, that many Kenyans want the judges to change the law, but that is outside of the separation of powers, and we are not able to. I think we can be empathetic to parties, but it's very difficult for us to change the law. And therefore, the responsibility of changing the law lies with Parliament, and therefore, you may want to throw that challenge to Parliament.
Thank you very much, Judge. One final question, then we now wrap it up. Wakili Osewa asked that in the case where parties were married under customary law, but then informally separated before the Marriage Act 2014 was enacted, can such parties petition the court for a divorce? We can have Justice Rechi, you can kindly assist us on that question.
Yeah, thank you very much for the question. If the parties were married and there's they now seek to terminate the marriage under customary law, yes, they can come to court, say I was married under customary law. This person I was staying with is cruel, is APCD, and I want it to be dissolved. We can do that. It doesn't have to, but he has to prove now that they were actually married. Or the other party will have to agree that we agree we were married under customary law. We'll do that, yes.
Thank you very much, Judge. We can have Lady Justice Njoki maybe give us her final reflections and comments on our topic today, and then we can have Justice Richie.
Much. I think that this has been a very interesting discussion. It's a very topical issue, and I think it will continue to engage us for a long time. I just think that it's important for us to realize that society is dynamic, and the environment is changing, and sometimes those who thought they had advantage under the laws of marriage previously may not have now. Before, it was women who used to say, our rights are being violated, we need our rights to this. But now, many women are propertied, and now we are seeing many more men coming to court, many more men who are homemakers, many more men who are taking care of their children, and therefore the laws of marriage need to be balanced between the genders. So I think that's something we just need to keep at the back of our minds. However, I think that moving forward, this discussion needs to move from an engagement of lawyers and members of LSK and judges, as we are also your members, and move into engaging other actors within government who can help us address this issue. I already talked about the Ministry of Education and the curriculum in schools. We've talked about the Attorney General and the Registry of Marriages, and in terms of even, I think earlier on somebody had said, would there be another extension that allows those who are registered to register? Again, that is the response we need to hear from the Attorney General. The Office of the President needs to tell us, in terms of customary law marriages and chiefs, how are they facilitating so that people in Mashinani, in the villages, are able to register their marriages? And finally, Parliament, will they have a look at the law in terms of the challenges we think we are now facing? So for me, I think moving forward, we need a multi-sectoral, multidisciplinary approach. And I really wish to thank you for giving us the opportunity to come and converse with you. It has been very interesting, and I hope moving forward, we will continue to engage with the LSK in
Justice Richie.
Let me thank you for this fruitful and engaging interaction. Something I wanted to say is that as you look at the Marriage Act, there's provisions. Section 68 provides for mediation of the issues arising from the Act, from the marriage and under the Act. Please, if you can, sometimes utilize them, and they can have better outcomes than perhaps the litigation we have. I know that we are, because of the way we look at mediation and how it assists us, we are having a family law summit on mediation laws summit in Kenya in April 2016, together with the Strathmore University. And we'll be engaging you, all of you, in activities towards that summit. I know the issue of marriage and matrimonial has been crucial to all of us, and Justice Njoki and I are engaging to have the Inns of Court family division. We are doing something to elaborate much more, have more people, get more players, group more players in this issue so that we can have a final and long-lasting solution for Kenya. We thank you a lot for this opportunity. And please, all of you, know that the matters that are family matters, the matter we have been discussing, are very emotive and very emotional. When you are handling them, please bear that in mind. And for your own benefit and the benefit of your family, know that emotions should be a temporary visitor, not a permanent resident in our lives. Thank you very much.
Thank you very much. At this point, I want to thank Lady Justice Njoki and Justice Riechi for honoring us with your presence, and for also agreeing to just join us for this topic, this interactive topic. We've really learned a lot. As a young advocate, I appreciate growing up. I was looking up to Justice Njoki, and today I am very proud and glad to just have us engage in this forum. We thank our chair for ensuring that we had this session, and my co-moderator, Wajuru Kiniti, thank you very much. We thank the Secretariat, Wendy, thank you for assisting us. Members, this would not have been possible without your presence. Thank you very much. And I've seen a few of my seniors on the platform, Senior Jenny Onyango, Senior Jackie Manani, Senior Rea Kigwatha, thank you very much for gracing us with your presence. And my colleagues, thank you very much. We will now call it a day, and I'm seeing that this topic has really brought a lot of discussions. We will look forward to having another session. Thank you very much. Members, we can leave the session as we please. Thank you. Yes, we will share the recording and the summary of the meeting. Thank you very much.